Good morning, everybody. I see some people are joining us, so let's give it a couple of more minutes for people to join. Yeah, happy Friday. All right, so it's 9:01, so I think we're gonna get started. Good morning, everybody. My name is Tanya Ash, and I'm Director of Programs and Member Engagement here at World Trade Center Denver. And this webinar is part of our tariff navigation series delivered in partnership with Colorado Office of Economic Development and International Trade through the State Economic Resilience Technical Assistance Program. The goal of this series is to give you practical strategies around sourcing, classification, compliance, so you can better plan and respond. We had 8 of these webinars, and if you missed any of them, please go on our YouTube channel and you can review all of them. We have heard so much positive feedback from all of you that we decided to schedule a couple of more. There is one coming up after this one and another one, potential one, so stay tuned for more details on that. And now I'd like to tell you a little bit more about World Trade Center Denver. We have supported companies navigating imports, exports, global operations for the last 40 years. And the last year, we worked closely with hundreds of businesses, specifically on tariff-related solutions. In addition to these webinars, we're also offering direct support. Through OEDIT, qualifying companies can access up to $1,000 matching reimbursement grant to help offset consulting cost. If you're interested, you can fill out the request form in the chat. Andrew will drop the link in the chat and schedule initial discovery call so we can walk you through that. I hope you can take advantage of that because it's limited and we still have a couple of them available. With that, it is my pleasure to introduce our speaker today, Luke Engen, partner at Gunnar Cook. Luke has in-depth knowledge of international economic and legal landscape. His range of experience in global trade, antitrust, and complex project leadership encompasses private and public sector roles. In international trade, Luke had deep expertise in tariffs, customs, export controls, and foreign trade zone programs. Luke devotes collaborative attention and taking an analytical eye to clients' needs, including litigation risk mitigation, cross-functional legal operation management, regulatory compliance, and antitrust international trade strategy. I'm gonna Well, Luke also had a lot of experience at Department of Justice, Federal Trade Commission, and Department of Commerce. So definitely wealth of expertise, and we are so excited to hear about today's topic on 301 tariffs. Luke, I'm going to pass it on to you now, turn it over to you. And if you have any questions, sorry, please put them either in the chat or in quick Q&A below. So we're going to have a little bit more time to answer those as well. Turned over to you, Luke.
Thank you, Tanya, for that great introduction. Since this webinar was scheduled, there's been a lot of activity. The information I'm going to present is pertinent to today. It's August 4th, 14th, 2026, and any subsequent developments may overtake my comments. But I think we at least chose the correct section of code, and Section 301 is likely to be the theme looking forward. In short, the government has moved on from using emergency powers for tariffs. Section 301 is now the operative instrument of U.S. tariff policy. And then most recently, the administration has opened a new lane under Section 338 of the Smoot-Hawley Tariff Act of 1930. So we're going to touch on that as well. I have a lot of information today. Much of it involves added supply chain costs, but there are some brighter areas. There are some workable strategies too. And I appreciate that introduction. I'll just quickly note that when I was in government, I assisted in tariff relief, eliminated case backlogs, and protected the government from suit. Now I assist businesses in advocacy, compliance, of course, suing the government back, and tariff mitigation strategies. Before we get to Section 301, let's give a quick review of how we got here and take a look at 2025 and 2026 in terms of the course of tariffs. So first, we'll walk through the Liberation Day provenance of these tariffs. In April 2025, the president adopted a package under the IEEPA statute, International Emergency Economic Powers Act. Those were near universal baseline tariffs once they were fully phased in roughly a year ago. And they were struck down by a Supreme Court decision on February 20th, making $166 billion refundable. And immediately with that decision was the stopgap, which was a Section 122 balance of payments tariff of 10%. This was statutorily capped to last only 150 days. And so the Section 122 tariff also expired on July 24th. At the same time, the administration adopted a Section 301 duty on forced labor tariffs applicable to 60 economies. And now, next week, we have a Section 338 tariff of 50% on $20 billion worth of Canadian goods. So we can count it as 4 to 6 policy shifts in just 16 months, depending on how you count it. That's a lot by any measure. It's not necessarily over. And these new developments have been flying at business with narrow windows of notice. And one thing I would point out is that a business whose financial model has built in a stable 10% tariff baseline from the start of this rocky timeline may very well have a better forecast than limiting that model to just discoverable facts at each point in time. Okay, this is a comparison of remedies. Why are we using Section 301 primarily when at the time of the VOS selection Supreme Court decision, the president rattled off 5 different tariff statutes that could be used instead of IEEPA? There are several laws on the books that have authorized executive branch unilateral tariffs, even though constitutionally Congress has supremacy on tariffs. They tend to leave these statutes on the books, which is why we've been seeing some experimentation in this administration using various authorities to support their tariffs. And Section 301 has emerged as the favorite in some respects, but Section 338 does contain broader authority because it's really sort of an empty sweeping kind of statute from the Smoot-Hawley era. I'll walk through some reasons for this drift. But Section 301 has express tariff authority, so there's not going to be another decision like the Supreme Court's VOS selection decision on similar grounds. 301 has no rate ceiling. The sunset provision is discretionary review under Section 307, so the default is for the tariffs to remain permanent. The procedural requirements are somewhat extensive, but the government spent the last 4 months pushing through them with litigation anticipated. They've done this before. Section 301 has oftentimes been the preferred route for unilateral tariffs. And Section 301 expressly allows tariffs on products unrelated to the act's policies or practices of the foreign trading partner. So we'll walk across how a Section 301 action works using forced labor as an example. Um, the initiation happened in March for this case. It's self-initiation as we saw it, which means USTR decided on its own to publish a Federal Register notice that it was going to look into forced labor and remedies. There can also be a domestic petition, although that's not how this one started. Next, consultations with every foreign government. These were extensive bilateral consultations. Comments. There were 2 rounds of general written comments, plus another 2 rounds of post-hearing briefs and 2 in-person hearings, hundreds of comments, 1,600 plus. Then determinations and remedies, ultimately, these were effective July 24th, announced July 23rd, and then there is no formal review outside of Section 307. Three features surprised people. First, the tariff doesn't have to touch the offending goods. Duties are expressly permitted on any goods of the economy, whether or not they're related to the Act's policies or practices. And that's in Section 301C3, subparagraph B. And this is why many goods that have no forced labor in their supply chain whatsoever have to pay a forced labor tariff. Second, the authority is with USTR, not with the president, although they have been frequently citing the president's direction. And third, there is no exclusion process. Excuse me, no exclusion process, because that is also at USTR's discretion. We typically have product-specific exclusions, but USTR expressly declined them, stating again it was inconsistent with presidential direction. The practical read here is that the comment windows were the exclusion process, and by the time the action is final, you are beholden to whatever is currently in the annexes. So next, we'll just go through the forced labor tariffs. What are they? There were 2 separate dockets, one for comment participation and the other for oral participation at the ITC. 60 economies were found to either fail to impose a prohibition on the importation of goods made with forced labor, or they had such a measure but were failing to effectively enforce it. The government said 54 of the economies had no restrictions at all. And the remaining 6, Canada, Ecuador, EU, Indonesia, Mexico, and Pakistan, had a law on the books that was not being effectively enforced, according to USTR. These 60 of our largest trading partners are responsible for 99.4% of US imports by value. That number has been repeated a lot. I know it's highlighted on this slide, but I want to point out that there are annex exemptions and there are exemptions where you are subject to either an MFN tariff or a 232 tariff, where that brings it down to effectively 30 to 50% of all U.S. imports have to actually pay the forced labor duty. All this high percentage means is if your good doesn't qualify for any of the exemptions, it's unlikely that a different country of origin is available that will make a difference. Let's look at the 2 different rate methods in the forced labor case. We have add-on on top of MFN, and then we have an all-in cap, which is effectively pay the greater of the two. So method A, the 301 duty is layered on top of the MFN rate. Method B, the duty is set so the combined rate hits a ceiling. And in fact, if MFN already meets or exceeds that ceiling, then that particular good does not have to pay the forced labor tariff. This worked example has a component with 3.4% as our MFN column 1 rate. And you can see that I've got Vietnam and Taiwan as potential sourcing countries. With Vietnam, it lands at 15.9% because there's a 12.5 base and we're using method A. And so you have to add in the 3.4 to that. Taiwan then falls under the 10% all in, and effectively the duty is 10% because the forced labor duty becomes only 6.6 in that example. So the delta in that case works out to 5.9%, the MFN rate, plus the difference between that 10 and that 12.5. And country coverage on this slide is per the USTR notice last month. It may change over time as agreements on reciprocal trade are concluded, or forced labor import bans are implemented, or enforcement is strengthened. Colorado Imports a fair amount from Canada, largest import source by a wide margin, and Mexico is the cleanest exemption. There's no 338 exposure at present on Mexican products. Um, China stacks with pre-existing China 301 lists. Malaysia and Indonesia also have TRQs pending. Brazil carries a separate 25% action, which is also under Section 301, but it does stack with the forced labor duty. Um, Colorado exported $10 billion in manufactured products in 2025. Uh, Food was about 2 billion, computer and electronics also about 2 billions. Chemicals and machinery were about 1 billion each. And the import side is heavy with Canadian and heavy intermediate goods. And with 87% of the state's exporters, small and medium-sized enterprises, a material share of this audience imports at low value and high frequency. CBP's June interim final rule suspended the de minimis $800 exemption indefinitely for all origins. I mentioned the annex exemptions making a significant dent in the 99.4% of all imports. So let's walk through what those families are. Family one, if a good already carries a 232 duty, the forced labor tariff does not stack. These are metals such as steel, aluminum, and copper, their articles, as well as their derivatives. In autos, we have passenger vehicles and parts, as well as medium and heavy duty vehicles and parts. Wood products, semiconductors, and then the most recent 232 is patented pharmaceuticals and active pharmaceutical ingredients just on July 31st. Families 2 and 3 are for our regional free trade agreements. Goods must independently meet the origin analysis under USMCA and DR-CAFTA. Family 4, Annex 1 grew by 471 subheadings after public comment. It has a whole range of products. Animal products, seeds, in quota, sugar, unflavored instant coffee, fertilizer, pesticide inputs, exotic leathers, eucalyptus, and wood products, vanadium oxides, pig iron, ferrous and aluminum scrap, aluminum hydroxide, battery waste, certain semiconductor manufacturing equipment, pharmaceuticals, and warm clothing. Then getting to family 5, there were negotiated Annex 2 lists for trading partners, including the UK, EU, Switzerland, Malaysia, Cambodia, Guatemala, El Salvador, Argentina, Bangladesh, Taiwan, Indonesia, Ecuador, and Jordan. Civil aircraft parks are exempt, but medical devices as a class were expressly requested and expressly denied. Take a look at the methods that define your invoice. Goods that are properly entered under Chapter 98 are exempt except where the duty applies to the value of the repair or alteration that happened at a foreign site. Send U.S. origin components abroad for assembly, and it's the foreign value add, not the whole article, that's used as the tariff denominator. FTZs, covered goods, must be admitted in privileged foreign status unless eligible for domestic status. Classification and rate lock at the time of admission. Still available is duty deferral, no duty on re-exports from an FTZ, no duty on waste and yield loss. And in drawback, the notice is silent on whether or not drawback is available. This is in contrast to the IEEPA orders. Section 301 duties historically have been drawback eligible. So if you re-export or destroy, the drawback may be your single largest recovery channel. CBP hasn't addressed it as of this webinar. And then stacking. These duties apply in addition to ordinary customs duties, except where capped by the method. AD/CVD and other Chapter 99 duties are stacked as well. And preference program eligibility alone does not shield goods, except for what we spoke about in the previous slide with regional FTAs. So there's been a lot going on. On July 15th, USTR finalized a separate 301 action against Brazil. This was for digital trade, electronic payments, anti-corruption enforcement, IP, ethanol, market access, and illegal deforestation. There's a 25% ad valorem tariff on most Brazilian goods starting from July 22nd. There are carve-outs. They include petroleum, coffee, beef, orange juice, nuts, aircrafts, and parts, and goods already subject to 232. Ethanol is not exempt. Brazil is also covered by the forced labor action at 12.5%, and the two apply cumulatively. Why this matters beyond Brazil is this is the template. Country-specific actions on country-specific grievances can be layered over the horizontal forced labor action for certain trading partners. And Canada is the next instance where there's a 301 and now a 338 coming into effect. So how durable is the forced labor case? We've taken a look at what the tariffs are, what they apply to, what's the future looking like, and this is going to touch also on the inevitable litigation. USTR devoted a full section of its notice to preemptive severability argumentation. Each of the 60 tariff actions is declared separate, 60 investigations rather than one investigation. Each exemption is severable from every other, and if an exemption falls, the tariff simply applies to the goods the exemption had covered. And this is in contrast to what happened with the IEEPA tariffs last year, where one holding in February collapsed the entire program. It's an admission and a strategy. USTR expects to be sued and has attempted to engineer the blast radius so only a single country or annex line can recover from the tariff, and the other tariffs would remain even in case of an adverse judicial decision. USTR repeatedly states it cannot accommodate comments inconsistent with the president's direction. So one of the several arguments is that the process was hollow. None of the comments or hearing testimony actually changed what the government was intending to do. And then again, we can talk about major questions doctrine, which is what a big part of the IEEPA case was about. Section 338 is in some ways a softer target. There's no implementing regulations or judicial precedent. There's no statutory process the way there is in 301 for adopting a 338 tariff. And there's even a live academic dispute over whether or not later trade acts implied a repeal of the 1930 law, and an open question whether there's an ITC investigation required. What a loss could look like is a court telling USTR to publish another FR notice and correct the way that it handled the comments. That would mean there's no change to the tariffs, no refunds, no limit of the range of subject imports. And it could also be a relief for one company or origin country alone with the other forced labor tariffs remaining in effect. So plan for these duties to persist. Do not plan for refunds, but preserve the claim. Litigation will probably take too long for pre-liquidation relief. So you want to be sure you've got your entry records going back to the time when the 301 tariff began last month. So I mentioned Section 338. What happens on August 19th when Canada tariffs become this new 50% stacked onto what's already there? The president used Section 338. This is the Tariff Act of 1930, the same one that was featured in Ferris Bueller's Day Off. There were three proclamations on July 20th. It was the first time Section 338 has been used. Duties are up 50%. Starting on August 19th on goods entered for consumption or withdrawn from warehouse for consumption. Grievances against Canada were a surtax order that was 25% on U.S. origin vehicles only, provincial boycotts of U.S. alcohol that didn't apply to other countries of origin, and dairy cheese quotas that were more favorable than the USMCA quotas. Excluded are goods already subject to 232. Civil aircraft and parts, excluding UAVs, and energy, potash, fish, and critical minerals. So, two potential action items here are that entries before August 19th do not pay. So, acceleration of entry could be a working capital question or a question what is currently in bonded warehouse eligible for removal. And FTZ merchandise admitted on or after the 19th must be in PF status, privileged foreign status. What's still queued? I was mentioning a lot has happened, but it doesn't appear to be slowing up yet. Let's look at some things I don't have much detail to share on, other than there are things we're watching and monitoring. Four pending actions right now. And the biggest is the highlighted bar in the blue. Structural excess capacity is also a Section 301 investigation that launched on the same day in March. It's nearly as broad as the forced labor tariffs. It's expected to come out in the coming months as USTR completes its investigation and completes its bilateral negotiations with our trading partners. The investigation into excess capacity covers 16 economies, and named sectors include steel, aluminum, autos, semiconductors, chemicals, and machinery. It is expected the government needs a couple months to complete work on this investigation, given that it devoted substantial resources to forced labor in the past months. And this is the largest single unpriced risk on the board. We don't have a proposal yet from the government as to what the tariffs are actually going to look like, but they could be broad. It targets manufacturing sectors directly, and its 16 economies overlap heavily with Colorado's supplier base. And then these others, China Phase 1 implementation was initiated back in 2025. The Vietnam IP case was announced on May 29th of this year. And Germany pharmaceutical pricing, also a 301, was initiated on June 18th, alleging persistent underpayment for innovative pharmaceutical products by Germany's health ministry. And that hearing is scheduled for September the 22nd. So I guess the uncertainty in this slide leads us to a planning posture where we treat the current landed cost and the forecasted landing cost as a floor rather than a settled number, and build a range in when we are anticipating future tariff burdens. So let's look beyond 301. I mentioned there were other tariff provisions. Section 232 gets exempted from some of these, but Section 232 investigations, as I mentioned, are still underway. So Section 232, the floor under everything, is 50% on steel, aluminum, and most copper articles, and then 25% on derivatives substantially made of those metals. Since April 6th, this has been assessed on the full customs value of the derivative and not merely its metal content. And the three metals regimes do not stack with one another either. The relief valves are closed. We don't have any product exclusions and haven't since February of 2025. Instead, we've now got rolling authority for commerce and USTR to add products at any time, but targeted relief exists. Combined duty caps of 10 to 15% through 2027 for agricultural equipment and certain other machinery, lowered the U.S. origin metal threshold from 95% to 85%. And then there's a de minimis of 15% as well. A few developments last month, the commercial aircraft and jet engine investigation concluded with a proclamation that directed negotiation and no duties, but that proclamation explicitly kept tariffs on the table for the future. We also have aluminum, copper, and pharma ongoing, and there are overdue reports on polysilicon, unmanned aircraft, wind turbines, medical devices, and robotics. Also, anthracite coal was initiated on June 29th. If you have to pay 232, you're exempt from 301 and 338. So for metal intensive goods, the classification question becomes which duty regime. And then there's the status of USMCA, which just went through its first joint review last month. The United States declined to renew in its current form. Mexico and Canada supported a 16-year extension, but without the 16-year extension, we are 6 years into the previous 16-year period. So we have a 10-year phase out at present with the possibility of negotiating the future of this pact. And the parties now enter annual joint reviews. Expiration will be July 1st, 2036, absent agreement. And the 16-year extension remains available at any time. So before July 24th, USMCA qualification saved you the MFN rate. Now it also saves the 10% Section 301 duty in the forced labor investigation. So for a Colorado importer sourcing from Canada or Mexico, the value of a properly supported origin claim may have doubled based on factual circumstance. And the corollary risk is that goods that are North American in fact but not qualified now pay 10%, they need not pay. So this is the highest ROI compliance review available to some attendees to get the certificate of origin. So for the rest of my prepared remarks, I am going to turn to how to respond to the costs and uncertainty, the exposure to these remedies, supply chain and commercial factors, tariff mitigation, the legal challenges, and refund eligibility. For step 1 of 5, I recommend assessing exposure along 6 lines: HTS, country of origin, MFN rate, regime for forced labor, all in, and 338. And 5 questions are deciding almost every line. Is it already a 232 good? In which case you've got neither 301 nor 338. Is it Canadian and on a 338 annex? Is it Canadian or Mexican and USMCA qualifying, in which case it's exempt from 301? And then is it in Annex 1 or the relevant Annex 2 country part? Is the origin a cap country or an add-on country? Which of the two methods, A or B, is being used? And that applies not at the port of export, but the country of origin. And then we can quantify 12 months of entry data gives you the annualized number, and the annualized number supports management decision making. And coordinate the pull across trade compliance, procurement, finance, and legal. Classification and origin data sit in different systems than the contract terms you'll need in step 3. And step 2 is manage supply chain risk. At a combined 15 to 60%, the cost of errors rise. First sale valuation, correct classification, and defensible origin determinations are material to margin. And errors are expensive on the way in and fatal to any later refund claim. Enforcement is scaling to match. The DOJ has stood up a global trade and enforcement section within its National Fraud Division. And the Trade Fraud Task Force reports over $1 billion in recoveries and penalties over less than a 1 year period. Document the reasoning behind every position you take. At this time, there should be a comprehensive audit trail. And on substitution, I guess I'd say that countries subject to the action provide 99.4% of all U.S. imports. So once your good is within scope, there's very little unaffected origin to move that trade to. The gap between the 12.5 and the 10% is small, as we've seen. And requalification can take months if you're looking at reengineering a supply chain to take advantage of a different country of origin. So if you start today, you're possibly landing in 2027. Um, and the lower duty tier economies may not have the capacity if people are piling onto Europe because Europe is a 10% all in. Then, the relevant businesses there may be taking on trade already. So engage early. And where you do move, build in conditional or phased supply agreements because all of this could change again at any time. Last column, the forced labor substance. Although it's not a part of the 301 action, watch the forced labor substance too. CBP enforcement has been active, and most recently there were withhold release orders on copper and apparel. Compile supply chain information defensively, obtain suppliers' forced labor policies, labor audits, certifications, and grievance procedures, and add compliance provisions with audit rights and remediation clauses, and map two or more tiers upstream. If your business or its customs entity is foreign, consider a U.S. importer of record arrangement. Refund rights and compliance levers run to the IOR. In step three, the commercial response. A duty you can't avoid is a pricing problem that can't be resolved using customs law. Here are some strategies in tariff mitigation. USMCA qualification review. This may be more pertinent now than before with the 338 coming into effect. Section 232 classification displaces both the 301 and 338 duty, and full value assessment since April makes it urgent independently if you've got derivative goods. The 338 Annex screen for Canadian goods has a 5-day fuse and the largest single rate on the board. Fourth duty drawback applies on re-exported or destroyed merchandise not yet confirmed for forced labor. Fifth, Chapter 98 makes U.S. components assembled abroad dutiable only on the foreign value add, and that's both 301 and 338. And sixth, first sale valuation lowers the base every regime applies to because most tariffs are ad valorem. You want to have a lower first sale. This has long been important for AD/CVD in-scope merchandise, subject merchandise, but today with these tariffs, it can be useful to check up on first sale for most goods, for most imports. Number seven, FTZs still deliver deferral, export relief, and savings, but no longer inverted tariff relief. You do have to use privileged foreign status. Annex advocacy. There is no product-specific exclusion process, but the lists have moved once during the second round of public comments. Country negotiations are live for the arts, and we can expect some change. And lastly, contract terms. Change in law is a possibility as early as late 2026. How do your contracts address that issue, and how do they allocate tariff risk? Move on to step 4 of 5. For the forced labor action, the window for administrative relief is already closed. Commenters requested an exclusion process. USTR declined, stating it would be inconsistent with the president's direction, and the only statutory channel is modification or review under Section 307. Relief comes from annex lists, expanded once already in response to comments, the country-level negotiations through the arts, and litigation currently beginning to be underway. Rates can migrate. Cambodia moved after the June proposal. Others have told USTR they're drafting legislation on forced labor. So your 12.5% origin could turn into a 10% origin in 6 months. No promises there, just a possibility to keep an eye out for. And then textile TRQs for Bangladesh, Cambodia, Indonesia, and Malaysia carry a 3-year initial duration with volumes keyed to each economy's purchases of U.S. cotton and textile inputs entering free of the 301 duty. But until USTR implements them by separate notice, covered textile and apparel imports from those four pay the 10% rate. Lastly, on refund, more than meets the eye is happening or may happen. Of the roughly $166 billion collected under IEEPA, CBP reported approximately $100 billion has been sent to Treasury for refunds, and $128.7 billion has been accepted for processing as of early August. Relief is tiered into buckets. We have phase 1 of CAPE, that was unliquidated entries or liquidated within the prior 80 days. Phase 2 was reconciliation and dump countervail entries, launched June 29th. Phase 3 is finally liquidated entries, but it is limited to CIT plaintiffs. And then outside of CAPE, the Court of Appeals for the Federal Circuit, rather, is viewing an appeal concerning whether or not non-plaintiffs can recover on finally liquidated entries. Do not rely on CAPE alone. Filing a protest may preserve your rights. Check Rev 615 and ACE for a CAPE refunds report. And then in the bottom right here, second and third possible refund claims. Section 122 is a live secondary claim, meaning it's uh, potentially on course for the future, but still going through litigation. The CIT has already held the surcharge to be unlawful. It was a 2-to-1 decision, stayed by the Federal Circuit, but the final outcome may be refunds. So preserve claim data between February 24th and July 24th for that possible refund. And then the third forward-looking claim is the 301 forced labor duties themselves. There are 2 CIT cases, so the protest and preservation discipline you built for IEEPA is what you need here. The government is fighting the order concerning non-party importers. If your entries are finally liquidated and you neither protested nor sued, the government's taking the position that you can't get a refund. So just quickly in summary, here are 6 things to remember. 301 is the tariff flavor of the month. The administration has turned to it its preferred authority over the other statutes, and that matches our historical experience. I would expect the 301 challenges both in court and through a potential trade bill, but we may be with forced labor and excess capacity duties for many years. Secondly, the Section 338 tariffs start next week concerning Canadian dairy, auto, and alcoholic beverage acts policies and practices, and it sits alongside 301 as a backup option. Legislation may seek to repeal 338. Third, know your stacking methods. Fourth, there isn't a product-specific exclusion process. Exemptions are in those annexes. And fifth, USMCA is more effective on 301 than on 338. And then sixth, the outlook. We have active investigations, the most sweeping of which is the 301 excess capacity and overproduction case. Litigation continues, and certain IEEPA claims haven't been fully resolved. Thank you very much, and I look forward to your questions.
Thank you so much, Luke. Oh my goodness, so much information and hard to keep up with everything. So thank you again for guiding us through every single details. And I loved how you had 7 sections. That was wonderful. Couple of questions came. Just I see one from Regina in our chat. And she said, how can I obtain a list of impacted HTS US codes under Section 232 and 301? Do you have any?
Impact lists. I'm sure somebody's come up with them. I don't have a comprehensive one handy. I'm sorry, Regina. Thanks for your question.
Yeah, that's a big one, for sure. Um, and then we also had a question about your. Oh, here we had another question. Can you clarify what is liquidated versus unliquidated entry mean?
Well, certainly. So at the time that merchandise is entered at the port, typically there is a bond, which we can think of as an estimated duty, uh, especially if there's a dump countervail order on the merchandise. It will take several months and an administrative review to decide the precise tariff amount, but there could also be protests and post summary corrections. So liquidation is a process happening months after entry, and liquidation is essentially settling the bill long after entry and long after the goods have entered U.S. commerce. And the other thing I would say is bear in mind the difference between liquidated and finally liquidated, because the liquidation may be protested as well. So when I was talking about 80 days past liquidation, that's CBP's way of saying there's this 90-day window. We want to do the refund before day 90. So give us at least 10 days effectively. But even beyond that, there's judicial estoppel that the government should reliquidate even after final liquidation. However, that's a more complicated process. So definitely good to keep in mind that if refunds come about for 122, act promptly because once things liquidate, the number of administrative options that you have for recovery can narrow. I know that might be more complicated than was wanted, but that's essentially liquidation in a nutshell.
Thanks, Luke. One more question. Given the level of complexity and uncertainty, is it realistic to think that average company, not the Amazons and Apples of the world, will be able to acquire refunds?
Yes, I would say smaller companies can obtain refunds. There's a possibility of using the Cape portal. There are AI tools and a variety of brokers who can assist. If it's already finally liquidated, it may be more for an attorney, somebody like me, because there may be a need to file at the CIT, even if it's just ha getting the filing in and then recovering under blanket order rather than having to litigate. Substantially cheaper than full-throated litigation, I would say. But Cape has been giving out refunds to smaller companies, and to the extent they're hiring outside help, many of these companies I have heard are recovering more than 90% of the funds themselves. So you can afford it.
Yeah, and I just want to say to add to Luke, we've heard from a couple of our members as well, smaller companies that were able to get the refunds. And just know that we do have support available at World Trade Center Denver. And again, with the support of OEDIT, you have $1,000 toward the consulting fee as well. So make sure you take advantage of this as it is still available. With that, let's all say thank you to Luke. Please comment in the chat what was the most useful or what are some of the insights you got today. Luke, thank you so much again for sharing your insights and the details. Again, it's such a complex question, and you really broke it down so that it's easy to understand. Um, Thank you. And with that, I would love to get Emma Howard from OEDIT to tell us a little bit more about the program, again, that I referred to a couple of times, but it's good to hear from Emma.
Thank you so much, Tanya, and thank you, Luke, for your webinar today. Really appreciate you taking the time to, as Tanya said, break down this complex issue and ensure our Colorado businesses have access to information as we continue to navigate changing tariff landscapes. In addition to the amazing services provided through a variety of detailed webinars from World Trade Center Denver, as Tanya has mentioned, we also are offering subsidized packages through World Trade Center Denver to connect with experts who can support the Colorado companies in accessing consulting packages, make it easier to access expert support as you continue navigating the changing tariff landscape, and to lower your cost to entry, to work with experts and ensure that your business is in compliance, mitigating risk and lowering your cost of doing business here in Colorado. In addition to the program offered through World Trade Center Denver, our Small Business Development Center network, located across the state, also offers one-on-one, no-cost advising on more general best practice for business. So please reach out if you have any questions about accessing those services. We also offer a number of access to capital programs through a variety of lending services at OEDIT and through our partners, that can help offset some of the costs that your businesses may be challenged with during this time of uncertainty with regards to the tariff landscape. I will put my contact information in the chat, so please reach out if you have any questions about this program, about OEDIT, about some of our access to capital programs. I'm happy to connect you all with any of the resources that we provide. And thanks again to Luke and Gunnar Cook and Tanya with World Trade Center Denver. Thank you all for attending the webinar today, and please reach out with any questions.
Thank you so much, Emma. And I just want to also say, OEDIT and SBDC Network has such a wonderful resources. So I just want to reiterate that as well. I guess my one thing is just ask, right? So let's see what we can all help you with. I see there were some people were asking about the contact information. There is some contact information now in the chat. It's also going to be in the email following this webinar. With that, I want to leave you with three things. Number one, the next tariff navigation on trade policy update going to be September 4th. So it's Friday again, 9 a.m. Mountain Time. So make sure to register for that. The second one, and Luke talked a lot about qualifying and reviewing your USMCA eligibility. We actually have a training on free trade agreements. So again, it's coming up next week. If that's something you need to review, please make sure to register for that class. And the third one, that's for World Trade Center Denver. Our largest event is coming up on October 6th. It's an annual gathering. So come meet us in person. Let's chat about tariffs. Let's chat about global business. Let's talk about, we're actually going to have a global economic update as well. So all that information is on our website as well, and will be in the email. With that, happy Friday. And as we say here, keep calm and trade on. Thank you, everybody.